Okay, so now the threat and altercation hadn't taken place yet when she met with them on July 19, 2000. And so the timeline is the exhibit where you show the tail wagging the dog, and you guys already seen the timeline. There's no way possible that incident on the 22nd could have influenced anything that happened on the 29th. We didn't establish that. And so back then, it says, Ms. Jones now admits she possessed a police report. It was her duty and obligation to disclose the police report to the defense before trial started, see? Because in post-conviction, she ended up having to admit that she possessed a police report, and this is why. It's because I knew you got to prove. See, the law is not about truth or lies. It's not about none of that. It's not about guilt or innocent. It's about what you can prove. A lie becomes the truth if you can't prove it's a lie. That's the courts. That's the real system. If you guilty, if you innocent and you can't prove you innocent, your ass going to jail. And so I knew I had to prove it. And so what I did is I was pressing like, I want the full discovery. I put in a motion for the full discovery. And then I got OCOT. And so OCOT, once I got an attorney, I couldn't speak for myself. So he was pressing the line to them. Yeah, because I also, man, he wasn't moving fast enough. So I filed a motion saying my lawyer was ineffective by not, doing it. And so the judge ordered that he get it done. So, they had to disclose that, the state had to disclose their full discovery all over again to us again. And so, in the meantime, while all this is going on, OCOT also goes to Portland Police Department and get the police report that happened on the 22nd that I just read you guys. He went and got that police report. So now, he got the police report in his possession. And so he know that I know once the state give us their disclosure, I know that police report is not going to be part of the state's disclosure. And so they disclosed the police report to us. I mean, they disclosed the disclosure, not the police report, excuse me. They disclosed the disclosure to us. And the police report wasn't in there. I'm going to read a couple documents. This is from my appellate brief, where it says, wait a minute. Well, I think we can go with this one. During post-conviction, Mr. McCool made a specific request for all discovery in the state's possession related to his case. So, after twisting arms and all that, I didn't put all that in the document, but after twisting arms, finally, on 10/9/14, the Multnomah County DA's office sent all the discovery they had to the state's AG's office. And so what they also sent was a letter. During post-conviction, Mr. McCool made a specific request for threat evidence. During post-conviction, Mr. McCool made a specific request for all discovery in the state's possession related to his case. And so on 10/9/14, Multnomah County DA's office sent all the discovery they had to the state's AG's office. And so here goes the letter. And it's from Rod Underhill, District Attorney for Multnomah County. It looked like Tony Shanley, Oregon Department of Justice. That's who received it, or that's who they sent it to. And it's in State versus Joel McCool 99-01-30212. And another number, so that's just my old case number. And it says, Dear Miss Shanley, I have enclosed all the police reports I could locate on the case, on Joel McCool's case. I have enclosed all the police reports I could locate on Joel McCool's case. I apologize that it took so long. I had to order the files from the office site location. Please let me know if there's anything else I can assist you with in this matter. And so this is from Shelley Carston. And so, yeah, they said it. I have enclosed all the police reports I could locate on Joel McCool's case. And so that's the document right there. And so they disclosed all. And so that's the thing. The police report that I read to you guys, this one right here, the police report was not included in that discovery. See, we gave you all that. Everything we got, we gave it all to you. This police report was not included in that discovery. And so the fact that that police report was not included in that discovery proves the state did not disclose the threat evidence to defense at trial level. It's just Key's order. So you got to prove it. You see what I'm saying? And so that proved it because my attorney got the police report in his possession. That same police report should have been part of the state's discovery. See, it wasn't. They realized they was trapped. And so what happened is, so now, see, look, the exhibit was a police report that was not included, nor part of the group of the police report Multnomah County sent to the AG's office, which demonstrates the prosecutor withheld that police report and never disclosed it to defense at trial level. Otherwise, see, that same police report, it would have been included in the complete trial level discovery file from Multnomah County that they sent to the AG's office. See, that's the thing, they was trapped. So now, Multnomah County sent the additional discovery approximately 15 months after October 9, 2014. So 15 months later, right, they didn't figure it out, they didn't got duped. Right? So now they trying to cover their ass, you know what I'm saying? So 15 months later, we got additional discovery. Voila, now 15 months later, we got the police report, the same similar one, except ours is a tad bit different. So, see, look, Multnomah County sent the additional discovery approximately 15 months after October 9, 2014. Attempting to protect the prosecutor. See, they sent the police report and some other just miscellaneous stuff. Said thereafter, petitioner submitted the objection to this new discovery, the additional discovery. I objected to it in a document basically, and so Olcott Thompson was trying to pull a move on me, but he couldn't do it. He couldn't follow through, and ultimately he did the right thing, man. So I ain't even gonna, I ain't gonna harp on it. But, shout out to Olcott because he ultimately he did the right thing by preserving the record. So, and Olcott been helping me since I've been out, you know what I mean? So shout out to Olcott Thompson, man, my old post-conviction attorney. Shit, man. And so yeah, so now they gotta cover their ass. See what I'm saying? So now they then came up with this new documentation. Oh yeah, they come up with this new the reason they got now, since they then came up 15 months later and then try to come out with this, you know, the documents to cover their ass. They gotta come out with the reason. So the reason is kind of long and heavy, but they admit they admit to discovery violations. It's crazy, and so all behind they trying to cover the DA's ass. See, because see what happened is, see, we did a deposition on the DA, right? On Nicola Jones, we did a deposition on it, where she said, you know, in her deposition, she testified in general that a PPB, so Police Department Bureau, whether it be street officer or detective, would generate reports and would send them over to the DA's office. And they would eventually make their way to the deputy who assigns the case and eventually make their way to the defense counsel. Ms. Jones also testified in major cases like attempted murder. She worked closely with detectives. It was her practice to meet with detectives, go over what they had, and make sure she had everything they had, and make sure the defense attorney had everything he or she was entitled to get. See, and so now Miss Jones possessed that police report, but didn't follow the procedures and general practices she laid out in her own deposition testimony when she withheld the police report, because she withheld it. Because this is how we know she withheld it, because Ocott got the document, he had it in his hand. We got the state to submit us with the documents that they had to complete all the whole file. That police report wasn't part of it. So now here comes the cover up, because they didn't realize what happened. And so Ocott Thompson, what he did was filed a request for admissions. And because the DA is on record about how she's supposed to proceed in this type of situation. And now they didn't realize, oh shit, the police report, he got us, because you know he's an attorney, so he talking under the table too. So he filed a request for admissions, and and uh and so their response to the request for admissions was this additional discovery. See, this new stuff. 15 months later, now all of a sudden you guys, oh yeah, you know we got that police report, but here you go 15 months later. So this is what they said. So he said, I am Multnomah County District Attorney who is currently assigned to review post-conviction relief matters and assist defense counsel in the AG's office in their litigation of contested case. I have become aware that there is a post-conviction challenge in Joe McCool v. Primo PCR case. This case arises out of a shooting that occurred on January 3rd, 1999. The case was filed in Multnomah County Circuit Court as State versus Joe McCool Circuit Court Case 9901-30212, DA 1185443-1. Mr. McCool was ultimately convicted by a jury in count 1 of attempted murder with a firearm, count 2 assault 1 with a firearm, count 3 through 5 the lesser included offense of assault 2 with a firearm, and count 6 through 10 unlawful use of a weapon. His convictions was affirmed in State v. McCool 22-1 ORAPP 56, and that was in 2008. I received a copy of Mr. Ocott's request for admissions as part of his litigation of post-conviction relief matter. I looked into this matter given the request for admission focused upon a possible missing police report and my seeing the potential confusion. I realized the importance of the accuracy and complete discovery. I reviewed our computer management system for electronic note. I reviewed the standard DA paper file. I reviewed the DA archive box of case material, and I've spoken with DDA Travis Sewell, and whom Mr. Thompson communicated about this matter the fall of 2014. I've reviewed the email communication between DDA Sewell and Mr. Thompson. This request for admissions has two exhibits. The first exhibit is referred in the request for admission as Exhibit 3. Paragraph 2 of the request for admission described Exhibit 3 as follows. All the police reports Multnomah County District Attorney's Office has regarding Multnomah County Circuit Court case, my case, State versus Oregon, State of Oregon versus Joe McCool. This request for admission letter referred to this exhibit as Exhibit 1. There's some confusion on the attorney's part trying to throw a curveball. It have reviewed this exhibit and it appears to be 80. I have reviewed this exhibit and it appears to be 86 pages of paper documents beginning with District Attorney cover letter dated October 9, 2014. In Exhibit 3, the letter by the Multnomah County District Attorney to the Oregon Department of Justice state that the enclosed police reports were all that I could locate on the Joel McCool case. The letter is signed by legal assistant Shelley Karshner. The exhibit contains police reports relating to Mr. McCool's shooting investigation. The Portland Police Bureau used 3 related police report numbers, one for each shooting victim. PPB case number 99603, 604, and then 6010. The documents in Exhibit 3 also include non-police reports such as a New Year's Eve party advertisement, grand jury affidavits, and an order to permit witness appearance by affidavit, a search warrant affidavit, and a letter from defense counsel Bill Brennan identifying witness and 3 defense witness investigative interviews. The second request for admission exhibit is referred as Exhibit 4. Exhibit 4 is a copy of the police report, incident report, which refers an assault reported 7/22/00, and then the exhibit has a Portland police number 0070879. The report is typed out and prepared by Officer Dahlberg. Note, in the request for admission, paragraph 4, Mr. Thompson states, the exhibit is not included in Exhibit 1. See, I believe he meant to write not included in Exhibit 3. This sentence is technically correct, that the 7/22/00 Dahlberg report was not contained in the 86 pages in exhibits, but given the inaccuracy and phrasing of paragraph 2 regarding Exhibit 3, it appears potentially misleading. But the bottom line is he admitted it. You know what I mean? This is technically no. He says in the request for admission page, Mr. Thompson stated, Exhibit 4 is not included in Exhibit 1. And so he said this sentence is technically correct, that the 72200 Delberg report was not contained in the 86 pages. The 86 pages is the pages, it's the complete file that the AG's office gave to him. And so that's the exact documents that the AG office gave to him. See, they trapped because all this is in their ecosystem now. They're responsible for it. You see what I'm saying? They can't get around them 86 pages because the AG's office gave the 86 pages to my attorney. And so, and they represented them 86 pages as all of the discovery. See, and that police report wasn't part of that discovery. See, that's the trap and trap. But now they're explaining it away. Said I reviewed the totality of the district attorney file material, and I found a similar copy. See, the cover up. Now all of a sudden you didn't found some shit 15 months later. I have reviewed the totality of the district attorney file material, and I found a similar copy of the 72200 Officer Delberg report, which the request for admission identified a similar copy as Exhibit 4. The copy which exists in the DA's attorney file material was not provided to the Department of Justice or Mr. Thompson on October 14th. He said this was a mistake and it was unintentional. See, none of that matters. Forget the unintentional shit. See, he admitted that they committed a discovery violation. The copy which exists in the district attorney's file materials was not provided to the Department of Justice or Mr. Thompson on October 14th. This was a mistake and it was unintentional. See, the unintentional shit don't matter. They admitted to the discovery violation, see? And they finna try to explain it away, but it don't matter. See, the cover up is the worst part. And so that's their problem now. So it says, I note the district attorney file copy is not the same as Exhibit 4, which is, the police report that my lawyer had. However, it is in substance very similar, with the only difference that on Mr. Thompson's Exhibit 4, the PP report number as well as additional left margin reference are present. I believe this Delbo report was provided to the defense counsel. See, here go to the cover up, y'all. Here go a cover up. And Mr. Brennan is dead, so said, I believe this Delbo report was provided to the defense counsel Brennan by DDA Jones. I spoke with Jones and briefly identified the material presented within the DA file. She observed that she did not she observed that she had not had access to these materials when she provided her deposition. She confirmed that she would have provided this 72020 or this 72200 Delaware report to Brennan as trial develops. Now she's saying she had the police report and she would have gave it to my lawyer, see? And so that's a problem because, see, if you possess that police report, you knew for a fact then that, or no, she's admitting now that she had the police report. So no, she had the police report. So she knew for a fact that, during trial that when she was bringing that evidence in to redeem the identification, she knew that that incident on the 22nd had no influence on the situation on the 19th. How she knew? Because she had the police report. See, she had the police report. Here she's saying, yeah, I had it and I gave it to Mr. Brennan. See, no, she didn't. How we know? Because we had an omnibus hearing on the 20th of October, where we made a specific request for threat evidence, and she told the judge she was not going to offer threat evidence during trial. See, you can't get around that pillar. She told the judge she was not going to offer threat evidence in trial, and the judge made a ruling and said, Mr. McCool, you should get that information. See, and that's the problem with this. So now she admitting that she had this document, a document that she used to coerce a witness, a document that she used to mislead the jury. You see what I'm saying? By making them believe that that incident on the 22nd influenced the statements on the 19th. See, they misled the jury. See, and so now, and so now the police report is in her hand. I spoke with Jones and briefly identified the material presented with the DA file. She observed that she hadn't had access to this material when she provided her deposition. She confirmed that she would have provided this 7/22/00 Delbert report to Brennan as trial developed. Production would have been consistent with her trial practice. Discovery would have been appropriate under relevant rules, and her personal ethics and disclosure would have been consistent with an effective communication and professional relationships he had with Mr. Brennan. Ms. Jones is willing to communicate with counsel further on these subjects. Again, she points out that at the time of her deposition, she had not reviewed her file. She was unaware that it had been retained after she left the district attorney's office. That's the cover up for private practice. She is willing to review it now and would do so if given an opportunity should the need for her deposition to be reopened. See, like, yeah, I'm willing to testify about it, whatever. You sure about that? Because man, if you do, you going to jail. You see what I'm saying? Because she coached the witness. They conspired to come with that spiel about the altercation influencing the exoneration statements. There's no way that could be possible. It goes against the laws of nature. See, that is no way possible that incident can influence the situation on the 19th. So, in my review, the district attorney found material in archive box identified additional reports that was not included in the October 9, 2014 discovery, district attorney letter to the Department of Justice. This is that. These documents were also missing by the DA's office staff in copying them for the Department of Justice, and thus was not presented in Exhibit 3 by this email. I'm including the district attorney copy of Delbert, the district attorney's copy of the Delbert 7/22/2000 report. The report copy is contained within what I have marked as Attachment A, and it also includes the document immediately preceding the following the report where they were found. I'm also forwarding the additional report not provided October 19th, 2014, and I have included them in what I marked as Exhibit B. Again, in discussing the matter on these reports with former DDA Jones, she is certain they were provided to Mr. Brennan as part of trial discovery. So in order to disclose these documents to Mr. Brennan as part of trial discovery, that means that you had to have them in your possession. Right, but when did you disclose these documents to Mr. Brennan then? Because we had an omnibus hearing 2 working days before trial started, and you told the judge you was not going to offer threat evidence during trial. Nowhere on the record will it reflect that you ever appraised the court or gave court any notification that, yeah, I changed my mind I told Judge Keys I wasn't gonna offer threat evidence, but now I changed my mind, I am, and I want the record to reflect that, see. And then here go the documents to support this evidence that I'm gonna bring in that I told Judge Keys I wasn't gonna bring in, see. No appraisal, no notice on the record or nothing, see. Because she, man, that's what happened. She cheated. And so now she's saying they scrambling, they trying to cover it up. You see what I'm saying? But now, okay, so now, if you had the police report in your possession, then why in the hell did you have, if you had the police report in your possession, um, why did you use that altercation to redeem the exoneration statement and you had the police report in your hand? So you knew there's no way possible that it could affect that situation, that altercation couldn't affect the situation on the 19th. You knew that for a fact because you had the police report in your hand and you did it anyway. See, and that's the thing. See, whether it's federal or state, these DA offices have the awesome power of the state behind them or the government behind them. All the resources in the world. And you shouldn't have to cheat to win. See, it ain't about you, it ain't about your promotion. It's about justice, it's about a country, it's about us having a country in the future. It's about the 14th Amendment and 6th Amendment and all these different amendments meaning something so we have a country. And nobody's bigger than the program. Rest in peace, Nipsey. Nobody's bigger than the program, and that's the thing. You can't cheat to win. And so you go and, man, you withholding documents because you know if you disclose the documents, you lose your rebuttal, you lose your redemption for your identification. You can't redeem her credibility without it. And so, you cheated and you got caught, and that's the problem. See, and that's why this is going on now. So here it is. She talking about she provided it to Mr. Brennan. Okay, that's good to know. You saying that because now you didn't put the police report in your hand. So we know you intentionally was gonna mislead the jury. That's what it was all about because you saying you had the police report and you lying talking about you gave it to Brennan because Brennan is deceased. And so now what follows is what I'm about to determine why this report and others were missing when the district attorney file material were provided on October in 2014. Communication about PCR discovery. Multnomah County District Attorney's Office learned of the pending Mr. McCool PCR case the fall of 2014. DDA Travis Sewell was then responsible for responding to PCR discovery requests. His assistant was Donna Clark. At the time this PCR case came into the office, she was in the process of preparing for retirement. Poor Donna Clark, they trying to, man, she's the scapegoat. And so, for the month before departure, Miss Clark was training her replacement, Shelley Karshner. Miss Clark retired on November 21st, 2014, after 3 decades of dedicated county service. And so he kind of insinuated that it was their fault, see? But we can call Miss Clark and Donna Clark to testify and Miss Karshner and see about how they feel. See if they want to accept, like, yeah, we the ones, it's our fault that the discovery violation took place. We'd take that. See, they probably gonna say, no, I'm not gonna lose my job for you. No, you did that, no. And see, they'll mess around and cover up more. You get deeper into the cover up and people ain't going along with that. And they say, nope, I'm telling on you now, see. You get these white folks in the guillotine, man. You get them in their guillotine, they gonna cover their own ass. Fuck that. And so here it is. This man is trying to blame Donna Clark and Shelley Karsner for the discovery violation. Hey, she was gonna retire and she did good years service. Okay. Our office received Mr. Thomas' subpoena on September 30th, 14. This subpoena sought all documents, the complete file regarding the prosecution of Joe McCool in Multnomah County case. Today, I would say the subpoena description of requested material could be better crafted for identifying what is sought. No, the man said all, everything. Give me everything you got. All means all. Not specific all, but all means all. Everything. And say, by letter date October 9, 2014, the District Attorney's Office provided police reports on Mr. McCool's case to the AG's office. These 86 pages of reports are what is labeled Exhibit 3. Mr. Thompson had communicated with DDA Sewell about discovery. Sewell's email showed Thompson called him on October 8th. They talked and followed up with exchange emails on October 9th. Thompson wrote, "It is acceptable to me for you to send me a disk with a copy of the documents your office is willing to provide me in response to my subpoena for your file. If I want further documents from your file, I will let you know and we can proceed as we see best." Thompson sent an email on October 31st to Sewell, DDA. I received 86 pages of discovery from the Oregon Department of Justice that has been sent to them by your office, DOJ, indicating you asked them to pass the attached on to me. Is this the complete response to the subpoena? See, he's straight up. Is this the complete response to the subpoena?